I'm going to be talking about the importance of titling your assets to back up your estate plan. Now, what do I mean by that? Oftentimes people have a will, and the will might say everything goes to my spouse, and then everything after, if my spouse doesn't survive me, then everything goes to my 2 kids, for example. And they think, oh, that's it. I've done a will. It's all done. My estate plan is done. I'm good to go. My affairs are in order. Let's back up a little bit and take a look at that. What does a will cover? Does it cover your house? Probably, unless your house is jointly titled with somebody else. Does your will cover your retirement accounts, your IRA, your 401k? Probably not. Those assets typically have on them a beneficiary designation. So let's make it very simple. Let's say you're a single person and you want everything to go equally to your 2 kids. And that's what your will says. But on your beneficiary designation on your IRA or your 401k, you named only one of your children, or you named, I don't know, somebody else. You didn't name the 2 kids like you did in the will. Well, if you have a beneficiary designation on that type of an asset, a retirement asset, that asset will pay to whomever you named on it. It's not governed by your will. What other assets are like that? Life insurance policies, same thing. If you have a beneficiary designation on it, it will not be controlled by your will. How about bank accounts? So oftentimes people set up, they might add one of their children to a bank account, and when that's done, they're not realizing that they're actually doing some type of estate planning, and they're getting advice from the teller who says, go ahead and just put, Susie on your bank account and jointly with you, and then maybe that'll even avoid probate, which means that your will, if you avoid probate, means your will has no effect. So if the person puts the name of one of their children on the bank account and it is jointly held with rights of survivorship, what happens to that bank account? It goes to the surviving owner, not to the 2 kids, not under the will, but it goes just to that one child. I've seen this quite a lot. People say, I'm just going to put my executor on and name them as the beneficiary and name them as the joint owner and do all this so that I can avoid probate. That is really fraught with a lot of problems. Why? After your death, if the child who you named as a beneficiary or put jointly on the account doesn't want to share, they don't have to share. They'll say, no, mom liked me best. That's why she put me on this account. That's why she named me as the beneficiary. The other child will say, but look at mom's will, and it says it goes to both of us, and the one who has all the money is saying, you're going to need to lawyer up because mom really wanted me to have anything despite what the will says. The will's not being probated. There's nothing to pass under the will. So it's not a good idea to do your own estate plan to set things up without understanding the consequences of this. If mom really wanted to avoid probate, then yeah, she'll have the will that says goes equally to the 2 kids, but what she'll do is she'll set up the beneficiary designation to say that it pays half to Bobby, half to Susie. And the life insurance the same way. And she won't make Susie a joint owner on her bank account. What she'll do is she'll say it pays on death or transfers on death, 1/2 to Bobby, 1/2 to Susie. That way they do avoid probate. The will supports everything that she set up. The problem is that understandably people don't understand the consequences of naming somebody as a joint owner or what a beneficiary designation really does, and they try to do all this themselves. Don't do that. Reach out to an estate planning and elder law attorney. Make sure you understand your estate plan. Find out if it's appropriate to avoid probate, and if it is, get the help and the guidance of the attorney so you do it right.